Thank you very much, Mr. Butinder, for introducing me. You were introduced the first African woman. I would add also that there is another major achievement, so far in almost 70 years, 69 years of the existence of the International Court of Justice. Some 105 people have been elected to this highest judicial organ of the United Nations. And Mr. Butinder was the only fourth woman. So you see, there is still a long way to go for women's empowerment and equality. But I have full confidence, as I also look at this audience, that girls, women, are now studying international and making legal careers. So I'm really sure the situation on the bench will further improve. In fact, this was during my tenure as president that I had the opportunity to sit with 3 women among 15 judges. So they represent now 20%. Dear organizers, excellencies, distinguished guests, ladies and gentlemen, I am delighted to be here at the commencement of the Hague Summit on International Law and Human Rights. And I thank Judge Butinder, my esteemed colleague on the bench of the International Court of Justice, and Mark Donfried from the Institute of Cultural Diplomacy for inviting me to say a few words at the opening session this morning. The theme of this summit is an interdisciplinary analysis of the role of international law in promoting human rights. International law has undoubtedly been central to the promotion of human rights on the global level. On its formation some 70 years ago, the United Nations was tasked with promoting universal respect for and observance of human rights and fundamental freedoms for all, without distinction as to race, sex, language, or religion. Since that time, following the adoption of the Universal Declaration of Human Rights in 1948, a significant number of treaties have been concluded focusing on the protection of various human rights. Among others, we might note the 2 1966 covenants, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, as well as the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention against Torture and other cruel, inhuman, and degrading treatment or punishment, or the Convention on the Rights of the Child and Convention on the Rights of Persons with Disabilities. So you see that the international legal framework for human rights protection has been substantively developed by the United Nations. In addition to this action on the global level, there have also been regional developments with various region-specific human rights treaties emerging, including the European Convention for the Protection of Human Rights and Fundamental Freedoms, adopted in 1950, the American Convention on Human Rights, adopted in 1969, and finally the African Charter on Human and People's Rights, adopted in 1981. As yet, however, there is no such regional convention in Asia. And in fact, also there is a lower level of participation of Asian countries in universal human rights instruments. While we should, where possible, give due respect and deference to cultural differences between peoples and their traditions, certain basic and universal human rights are recognized internationally and embodied in international legal obligations assumed by states. Those states are obliged to conduct themselves in conformity with these obligations and to uphold fundamental human rights both internationally and domestically. Human rights have in principle to be implemented at the national level. It is therefore important that a number of parliamentarians will participate in this conference, as it is their responsibility to enact legislation fully in conformity with international human rights standards and to provide national judiciary with strong powers and necessary resources to discharge their key role in protecting human rights and providing recourse to judicial means of redress. A challenge facing the international human rights system is how to enforce those obligations when states do not live up to the standards they have agreed upon. On the one hand, a number of global treaties I have mentioned do not contain compromissory clauses allowing disputes to be brought before the International Court of Justice. While the principal judicial organ of the UN is not primarily a human rights court, it has had occasions to deal with cases in the past which raised the protection of fundamental human rights either as a central or at least important issue for adjudication. To take a few examples, in 2010 the court gave judgment on the merits in respect of dispute between the Republic of Guinea and Democratic Republic of the Congo regarding the treatment of one of the former nationals, Mr. Amadou Sadio Diallo, finding that the respondent, Democratic Republic of Congo, had violated provisions of the International Covenant on Civil and Political Rights and the African Charter on Human and People's Rights. In 2012, the court decided the case called the questions relating to the obligation to prosecute or extradite between Belgium and Senegal, which concerned the latter's alleged failure to prosecute Hissène Habré, former president of Chad, who allegedly was responsible for torture and other cruel, inhuman acts, and in which the court found Senegal to have breached two provisions of the Convention Against Torture. The court has also opportunities to clarify certain human rights issues, including human rights protection in the course of armed conflicts, so-called international humanitarian law, in two advisory opinions, one in 1996 concerning the use or threat of use of nuclear weapons, and then in 2004 in the advisory opinion concerning the construction of the wall in the occupied Palestinian territory. On the other hand, notwithstanding that some cases concerning human rights have come before the court, there are at least two reasons to be cautious when relying on the court's dispute settlement procedure to be a truly effective tool for the enforcement of human rights obligations at the international level. The first is that the court's jurisdiction depends on state consent, and not all human rights treaties contain compromissory clauses conferring jurisdiction upon it to adjudicate cases concerning the interpretation and application of the relevant instruments. It is therefore not always possible for human rights disputes to be brought before the court. The second is that interstate litigation may not always be the best mechanism to address injury done to individuals, with the decision by a state to bring a claim on behalf of its national often remain dependent on many factors, including political ones. The latter issue has been addressed, at least to some extent, by the fact that a number of regional conventions contain dispute resolution mechanisms that enable individuals to bring their own claims against states, and that some other treaties provide for individual complaints to be brought before treaty bodies. However, such enforcement mechanisms are not universal and remain dependent on the consent of states parties to the relevant instruments. I think this brief overview has merely touched on one challenge facing the implementation of human rights at the international level, rights that are recognized fairly universally, but the enforcement of which may face obstacles. I understand that the purpose of this summit is to advance proposals for the further development of an effective international legal system that promotes and protects human rights. In this regard, I have no doubt that this event will generate thought-provoking and timely exchanges and hopefully bring us one step closer to achieving these important objectives. And I wish all participants much success in this endeavor. Thank you.